Hello, everyone. Welcome back to Stay in Your Lane. I'm your host, John Maley, brought to you by Triple T Transport. Today, we got one of my dear friends, Thomas Kern. You guys have seen him before on the Supply Chain Squares, and you've also seen him on an earlier podcast we did last year talking about AB5. Well, I invited Thomas back because I like Thomas. He is a partner with Walter Haverfield, so those of you that might need some legal support or direction in the future, you're going to want to look up Thomas Kern. He's a partner at Walter Haverfield. But the purpose for today is to get an update on where we are, on where we stand on AB5.
Absolutely. Yeah, we should probably just do a quick background, right? So the district court enjoined enforcement based on F4A. It was appealed. The Ninth Circuit dissolved the injunction. It then got kicked up to the Supreme Court of the United States, who denied to hear it. And then so it goes now back to the district court to do what the appellate court had told it to do, which was to dissolve the injunction. However, a new party has come into this case.
OOIDA.
Yeah, and they're on fire. I mean, they filed for an injunction not based on F4A, but based on the Dormant Commerce Clause. The Dormant Commerce Clause. It's a theory that was raised early but never litigated really. So they have filed an injunction for that. A response is due, I believe, in March from California, and the injunction will be heard in May. Okay. So we've got a few months, 5 months, until we get another update there.
So if I remember correctly, OOIDA stated it was unconstitutional, AB5. And the reason for that was it was an unfair playing field between the other 49 states that do not have any of those type of laws, right? So California, help me,
Yes,
dumb this
absolutely.
down for me, Thomas.
Yes, absolutely. So the Dormant Commerce Clause is a theory where the states' restrictions can't be so burdensome on on interstate commerce, essentially. So while you have the right to kind of do what you want as a state, it can't it can't put an undue burden on interstate commerce, and it can't be discriminatory from out-of-state businesses and things like that.
So that makes much more sense compared to the federal aviation attempt.
Yeah, it's in both. The F4A had a lot of, on its face, maybe didn't look like it would have been the big winner here, but there's a lot of precedent that I think beefed it up. In the district court, obviously, Judge Benitez, I believe, agreed that F4A was a good argument there. Ninth Circuit didn't. However, I really like the Dormant Commerce Clause argument. I think it's clever. It certainly does cause an undue burden on commerce. There's very few, if any, other states that have independent contractor laws that are this strict or cut this deep. And we had the Borrello test and other laws that
The ABC test, yeah.
that were fine. They worked just fine. And so that will likely be the argument, or likely is the argument of OOIDA, that, hey, look at this burden that you're causing on everyone trying to do business in California. We had these laws that classified the independent contractors just fine. And, as stated, I believe, in the brief of OOIDA, they hadn't seen any instances of misclassifications under the Borrello test. So there was law there that was kind of fine. They made it stricter, and now they've made it harder for other companies to come in there and do business, and that is sort of the undue burden.
So what the injunction states, Thomas, if I'm listening to you correctly, it says that one state can't be far off from all the other states.
Right, unless,
From an
I mean, there's a
interstate commerce, basically dumb it down, right?
right, and there are exceptions, like public safety or congressional authority. So there are sometimes exceptions, but generally, absolutely. So there's like a case out of Oklahoma at one point. That's a famous Dormant Commerce Clause case where if you were driving through, it might have been North Dakota or something, I forget. It's been a while since I had con law, but you had to get out and change your mud flaps, right? They had strict rules on mud flaps on trucks and when going through that state. So if you were going through that, you were technically violating state law because your mud flaps were not the proper size. Things like that where you got to then stop, get out, change your mud flaps just so you can drive through Oklahoma. Obviously, that creates an undue burden.
Correct.
So it's a kind of a similar thought here. Now, then there are other instances, such as Michigan has a law that's been challenged before under the Commerce Clause that you have to label all the food, all the body parts in any meat that may be, that you're packaging and selling. But only Michigan has it. And so obviously the argument was, well, this puts an undue burden, but Michigan had that burden on its own citizens as well, and it was a health and safety issue. So they were allowed to get that through. Here, I don't know that you have those exceptions. You have the undue burden. Where it may cut is that burden also falls on its own citizens. So California citizens are burdened by this, not just people coming through California.
Right.
And when that's the case, sometimes it doesn't have it's just a bad law for everybody. And that's a little bit different. That's where it kind of cuts both ways, right?
Right.
Where it's not necessarily discriminatory against out-of-staters because the people there also have this tough law to live by.
It's not discriminatory to anyone who's not working based out of California. It's discriminatory for everyone that is based in California. Because just because you're based in California, if you're an over-the-road truck driver,
right,
and you're an owner-operator, and you're leased to a trucking company, let's say you're on a lease purchase. So you're driving for the company as well as paying off the equipment.
So getting fruits, vegetables, things from California to other places, you're now creating an undue burden on interstate commerce because they can't sort of export it to another state.
Right.
It's clever.
It's going to be basically another tax.
Yes.
And then you have the union involvement from a port perspective.
Yes. Enforcement right now too. I've read some articles, talked to a few people about it. It's still, I think everybody's just trying to figure it out.
Right.
I don't think you're going to see real aggressive enforcement before May.
So what happens then? They choose to leave California.
Right, which is what they're already seeing an exodus out of California into
Been
Texas.
watching it.
And that will
Oklahoma and Texas.
I'm not certainly not criticizing or anything, but it in the big scheme, it calls you to sort of be isolated. Who's going to bring things?
Right.
Now, obviously, it's warm there all the time, so they have all the things they would need. But people will, rates are going to have to go up to even get people to go there. The native drivers are likely.
They're going to have to raise rates.
And they're sort of transient anyways. A lot of times the drivers and transportation folks move around. I think you'd admit that. It's not uncommon that they go to different states. I predict if this goes through, they're going to see some real crunches. And obviously it affects not just trucking, lots of industries.
Oh, yeah. It'll affect everyone. It's gonna go deep. I don't see a positive other than if the OOIDA position wins out in May, which I think we all hope happens. I think that
there's a real chance.
Yeah.
I mean, it's a real argument.
This is a legitimate, fact-based argument from OOIDA. So they're requesting an injunction. At some point in time, either, is California going to give up on this, or are they going to keep driving the bus, right? So, for those of you watching, Thomas has a lot of background, a lot of history. That's why we have him on here. We haven't seen enforcement. Moving forward, nothing, I would expect nothing will change until we have a judgment in May on the injunction request, correct?
Yeah, I don't think I don't think the state has filed its brief in opposition of the injunction. So when that comes in, I'm going to check in on that. That'll probably, just to see what the arguments are against.
We'll have you back on when we have that.
But that will likely be the last update, and then there'll be the district court injunction hearing. So it's back in front of Judge Benitez once again, who, remember, has already granted one injunction.
Right. And then he requested the Supreme, they wanted to push it up to the Supreme Court.
Yeah, when it was appealed up to the Ninth Circuit and then to the Supreme Court, it comes back down now to Judge Benitez to dissolve the first injunction and now hear this second piece.
So right now, if there was a way to enforce it, legally California could enforce it.
Yeah.
Today.
I wouldn't suggest, obviously we would suggest to comply.
Right.
And to use some of those ideas that we had in our first podcast together on this, to ask somebody to just change their entire business model overnight. That's
I
tough.
don't think it can change without. I think
people will leave.
People are leaving.
That's the.
Yep. Where they're filing for their own authority, they can't be leased on to anybody else.
Right.
It's one of the two.
If the industry has always kind of done things one way, and now the most populated state says not anymore, that's going to take a minute to adjust to, and that's why I said I can't imagine everybody's just going to get hammered with non-compliance and things. I think it will, be a warning like, hey, we got to do these things. That would be my guess as far as enforcement. But we'll see come May. I think they got a real shot to get this enjoined, and obviously all of the industry folks are sort of rooting for that.
Yeah, absolutely. Well, Thomas, as always, thank you. Appreciate you.
Oh man.
All right. Thanks for coming on. Thanks for sharing your knowledge with our viewers. And we look forward to hearing an update. We're waiting for...
we'll see the briefs filed, and maybe some of the pleadings going back and forth.
When do you think we'll see that?
I'll get in... I think the opposition brief is not due till March, I believe I saw. But I'll check back in on that.
So February, March...
we'll check back in.
All right. That sounds great.
Absolutely.
Thanks for being on.
Thanks for having me, John.
All right, bud.